5 seconds to go. Start. Shri S. N. Bhat, learned counsel for the appellants, mainly contended that the compensation awarded by the tribunal as confirmed by the High Court is on lower side and is not just and fair. The learned counsel has contended that the compensation was awarded by assuming income of the deceased notionally at rupees 15,000 per annum as per Schedule 2nd of the Motor Vehicles Act 1988, which is applicable to the claims made under Section 163A of the Motor Vehicles Act 1988. It is submitted that the notional income of rupees 15,000 was fixed as early as in the year 1994 and somehow the same is continued in the statute without any amendment in spite of repeated directions by this court. It is submitted that in view of the provision under section 163A(3) of the Motor Vehicles Act 1988, though it was obligatory on the part of the government to amend Schedule 2nd, same as fixed in the year 1994, continued since then. Thus, it is submitted that the notional income as fixed is to be considered by taking into account increase in the cost of living. In support of his arguments, the learned counsel for the appellants has relied on the judgments of this court in the cases of Puttanna and others versus K. L. Narayana Reddy and another. On the other hand, Shri V. S. Chopra, learned counsel for Respondent No. 2 Insurance Company, has submitted that there are no grounds to interfere with the impugned judgment of the High Court and placed reliance on the judgment of this court in the case of Rajendra Singh and others versus National Insurance Company Limited and others. Having heard the learned counsel for the parties, we have perused the impugned judgment and the other material placed on record. As the claim was made under section 163A of the Motor Vehicles Act 1988, since the deceased child was not an earning member, the tribunal has considered notional income as per Schedule 2nd for the purpose of fixing compensation. The tribunal has awarded compensation by taking notional income of the deceased at rupees 15,000 per annum by applying multiplier 15, awarded compensation of rupees 2,25,000 towards loss of dependency with interest at the rate of 6% per annum from the date of judgment, when the appeals are preferred by the insurance company as well as the appellants herein by the impugned common judgment. The High Court has dismissed the appeal preferred by the insurance company and in the appeal preferred by the claimants, while confirming the compensation awarded for loss of dependency at rupees 2,25,000, has awarded a further sum of rupees 15,000 towards funeral expenses and accordingly granted a total compensation of rupees 2,40,000 with interest at the rate of 6% per annum payable by Respondent number 2 Insurance Company and by permitting it to recover the same from Respondent number 1 owner of the motorcycle. In the judgment, in the case of Puttanna and others, this court has observed that the central government was bestowed with the duties to amend Schedule 2nd in view of Section 163A(3) of the Motor Vehicles Act 1988, but it failed to do so. In view of the same, specific directions were issued to the central government to make appropriate amendments to Schedule 2nd, keeping in mind the present cost of living. In the said judgment, till such amendments are made, directions were issued for award of compensation by fixing a sum of rupees 1 lakh only towards compensation for the non-earning children up to the age of 5 years old and a sum of rupees 1,50,000 only for the non-earning persons of more than 5 years old. In the case of R.K. Malik and another also, this court has observed that the notional income fixed under Section 163A of the Motor Vehicles Act 1988 as rupees 15,000 per annum should be enhanced and increased as the same continued to exist without any amendment since 14th November 1994. In the case of Kishan Gopal and another, where the deceased was a 10 years old child, this court has fixed his notional income at rupees 30,000 per annum. The enhanced compensation shall be apportioned between the appellants as ordered by the tribunal. The entire compensation shall be paid to the appellants by Respondent number 2 Insurance Company, and we keep it open to the Insurance Company to recover the same from Respondent number 1 owner of the motorcycle by initiating appropriate proceedings, as the motorcycle was driven by the driver who was not possessing valid driving license on the date of the accident. Accordingly, this civil appeal is allowed partly with directions as indicated above. No order as to cause. Stop.